As a result of President Trump's $10 billion lawsuit. Now, people need to say, are you okay with one person in America, because the Secretary of Treasury, I'm guessing, conferred with the Department of Justice.
And
I know, here's his filing, sir, of all the insider trading. Right here.
Do you want to apologize on behalf of the American government?
Scott, you should apologize to the American people for fleecing.
You need to see the actual footage that's about to play. Senator Luján corners Secretary Bessent over a massive $10 billion lawsuit and a shocking $1.776 billion settlement. Watch what happens when Luján reveals a secret addendum for tax immunity. Stay tuned to see how this heated confrontation ends.
Thank you, Mr. Chairman. Secretary Bessent, should Americans who illegally evade their taxes be investigated and prosecuted?
Yes.
Secretary Bessent, should people and organizations facilitating money laundering for Iran, North Korea, or Hamas be prosecuted?
Yes.
What about laundering money for Mexican drug cartels?
Yes.
Should a person who traded and profited on insider information be prosecuted?
According to the law, they should.
Appreciate that. Mr. Secretary, as a result of President Trump's $10 billion lawsuit, the Department of Justice, on behalf of your department, settled with President Trump by creating a $1.776 billion slush fund to pay for his supporters and criminals. Were you either directly or through your staff asked to sign the original agreement?
Senator, you were not here at the early part of the meeting.
I saw you on TV.
Well, congratulations, and you would know that I'm unable to answer those questions, and they should be referred to
Mr.
Attorney
Secretary,
General Blanche.
what about the addendum to this agreement? Are you familiar with what the addendum is?
I'm not sure what you're referring to.
Are you familiar with this giveaway from the IRS that says President Trump and anyone that knows him or does business with him or part of a business, they get off scot-free? Are you aware of this?
Again, I refer you to Attorney General Blanche.
What you just witnessed was not a simple disagreement over protocol. Scott Bessent looked Senator Luján dead in the eye and flat out evaded responsibility for a massive $1.776 billion arrangement, even as he was confronted with a document naming his own department. This isn't just a simple mistake. It looks like a deliberate attempt to keep things hidden. And let's be crystal clear, this $10 billion lawsuit didn't emerge from nowhere. It is built on documented civil actions where the Treasury is a named party, meaning the Secretary is legally bound to know every single term. According to established guidelines, the IRS is mandated to conduct annual checks on high-profile leaders to ensure absolute fairness. Yet Bessent immediately deflected by questioning Luján's internal knowledge rather than addressing the actual text of the agreement. This is who the Treasury Secretary is in this moment. He proudly claims credit for global financial sanctions, but refuses to answer for a domestic addendum providing absolute protection. He hides behind procedural talk, but everybody watching knows exactly what's happening. He is allowing the Department of Justice to dictate terms that completely bypass public scrutiny. Accountability to the taxpayer, that's the only thing that should matter now. But watch how quickly this excuse falls apart in the next clip.
Are you Attorney General Blanche's client?
The IRS and Treasury are a client of the Department of Justice.
So is that a nice way of saying yes? You're a client. He's your lawyer.
He represents...
You're the Secretary. Are you the Secretary of Treasury? Yes is the answer.
The Department of Justice.
Scott Bessent, let me ask you this question, sir. Are you the Secretary?
In my personal capacity, Tom Blanche is not my attorney.
Correct, sir.
Are
you, sir?
For the
Mr.
U.S.
Secretary,
Treasury,
Scott, let me ask it this way. Scott, are you the Secretary of Treasury for the United States government?
Yes.
Appreciate that. The Department of Justice represents the IRS and the Department of Treasury in this lawsuit, correct?
Correct.
Are you aware of this addendum? You're telling me DOJ gave the president this without you knowing about it?
Again, they settle on our
All right,
behalf.
well, that's not how the law works, sir. I'm not a lawyer, but you have a bunch of them behind you. You should see the faces they're making at me behind you. They're all scowling at me back over here.
Well, I think that's a different reason, sir.
Well, for whatever it is, they're doing it. Mr. Secretary, my concern is that this addendum's not been getting a lot of attention. There's colleagues on this panel that think this slush fund is a bunch of bullshit. And they've called out to say, get rid of it. Now, people need to say, are you okay with one person in America, because the Secretary of Treasury, I'm guessing, conferred with the Department of Justice, because you're named on this lawsuit, sir. These are all the transactions from the president as well, that I'm going to ask you this next question as well. You were bragging to one of my colleagues that you've been sanctioning people doing bad things in America. People that get sanctioned, like Iran or terrorists, they're told not to do business in the United States with partners. Is that your understanding, sir, me as a layman?
It is.
This entire exchange perfectly illustrates how the system is manipulated to dodge responsibility. Scott Bessent tried to deflect by separating his personal affairs from official actions, completely ignoring the fact that the Treasury itself is the institutional client bound by this multi-billion-dollar deal. This wasn't a minor technical detail. It was a deliberate pivot to downplay his own involvement. Let's be clear. This client status is a matter of basic governance, where the Treasury routinely relies on the Justice Department to execute these massive settlements. For decades, the Treasury's enforcement divisions have taken credit for sanctioning foreign entities and securing national financial systems. Yet, when Luján exposed a domestic addendum that allegedly carves out an exclusive exemption for well-connected individuals, Bessent chose to sidestep the entire contradiction. This is the reality of the situation. You cannot celebrate strict enforcement abroad while turning a blind eye to selective protections at home. He hid behind legal jargon, but anyone watching can see right through it. Equal treatment under the law is the only standard that matters. Keep watching, because the tension boils over in the final moments of this hearing.
You hold these bad people accountable. I congratulate you for that. So this little giveaway to President Trump and his family gets them off scot-free. Does every American become part of this addendum? If someone didn't pay their taxes or violated tax law or did bad things, are they told, can't prosecute you, you're good? Everyone going back to the date of this, or is this only for President Trump and his affiliates?
Senator, do you have specific knowledge that President Trump's being audited?
Sir, I have specific knowledge of this addendum that you don't know a damn thing about. That is for the Department of Treasury that your lawyer at the Department of Justice signed you up for. The reason I'm asking this question is because President Trump's sons signed a deal, as you know, with World Liberty Financial with a bunch of folks you sanctioned. And now, as part of this, there's an addendum that says President Trump and his kids and anyone affiliated with him, I don't know if it's current wives, former wives, people that just did transactions with him, they're off scot-free. That, you know, that has a new way, a new ring to it, this thing, scot-free, because the Department of Treasury and the IRS is not going to go after him, sir. This is wrong. This is lawless. I hope our colleagues will look at this addendum. If I could offer this into the record, Mr. Chairman, for those that haven't seen it yet.
Without objection.
Come on, man. There's a better way of doing this, sir. That's all we're saying here. So, look, I appreciate it if you don't want to talk about a lawsuit. That's your prerogative to answer that way. But to say that you as a client, as Secretary of the U.S. Treasury, does not know what the Department of Justice is giving away to people, come on, man. That's just not on the up and up, sir. I hope we can do
don't
better.
understand the way the protocol works, and we receive advice and accept their settlements.
You're telling me as the Secretary of U.S. Treasury, you don't know that the President of the United States, who I think you work for, got a sweetheart deal from the Department of Justice, who's your lawyer.
I do know.
You're in line for the presidency, Scott.
I do know that
Man.
the President of the United States and 400, many of his employees had the largest tax leak in history. And
I know. Here's his filing, sir, of all the insider trading. Right here.
Do you want to apologize on behalf of the American government?
Scott, you should apologize to the American people for fleecing them and giving this away to Donald Trump, man. That's what you should do.
We can agree to disagree.
Senator Warnock.
Did you notice the exact moment the defense completely fractured? When pressed on whether this secret addendum creates an exclusive shield against tax enforcement, Scott Bessent didn't issue a single denial. He didn't claim the document was fake, and he didn't say the report was wrong. Instead, he fired back by demanding to know if Luján had insider knowledge about the status of ongoing audits. That is not a rebuttal. That is a deflection into a completely different question, and it is a revealing one. The IRS has a long-standing policy, not a law, but a formal policy, that sitting presidents should be audited every year. It is an automatic process. It is not discretionary. It exists precisely to prevent any appearance that the president is receiving favorable treatment from the tax authority he oversees. If that process has been interrupted or altered by a settlement addendum, that is not a procedural curiosity. It is a direct collision with a foundational norm of democratic accountability. Luján's response shut down the excuses immediately. He named World Liberty Financial directly. That is a cryptocurrency venture that Trump's sons, Eric and Donald Jr., were involved in promoting. Treasury's own OFAC sanctions list had flagged individuals connected to that financial ecosystem. Luján's point was specific and pointed. How does an administration that sanctioned people in that space simultaneously extend legal protection to the family members who did business with them? That is not just political talk. It is a factual contradiction that sits at the center of this whole exchange and that Bessent never addressed. The phrase "scotangent-free" that Luján used carries more weight than it might appear. In tax enforcement, a civil settlement between the DOJ and a private party does not automatically prevent further legal action. Those are separate tracks. But an addendum to a civil settlement that explicitly instructs the IRS not to pursue certain individuals would effectively collapse both tracks at once. If that addendum exists as described, it would be highly unusual. Civil settlements involving the IRS typically resolve specific disputed tax liabilities. They do not, as a matter of standard practice, grant forward-looking immunity to an entire category of people defined by their relationship to one person. That is what makes this addendum, if accurate, so constitutionally significant. It would use the machinery of a civil settlement to accomplish something that would normally require a presidential pardon or an act of Congress. Bessent's defense that Treasury receives advice and accepts DOJ settlements is procedurally accurate in a narrow sense. Federal agencies do defer to DOJ on litigation strategy. But there is a meaningful difference between accepting a litigation outcome and being unaware of the substantive terms of what was agreed to. A Secretary of Treasury who does not know what protections were extended in a settlement that names his department is either not being told things he should be told or not asking questions he should be asking. Neither explanation is reassuring. The table-slapping moment when both men hit the surface almost simultaneously is worth pausing on. That kind of physical reaction doesn't happen in Senate hearings just for the cameras. It happens when the emotional temperature in a room reaches a point where people can no longer contain their frustration behind formal language. Luján slapped the table because he was holding a document he believed proved something serious, and the man responsible for the institution involved was telling him he did not know it existed. Bessent slapped the table because he felt cornered and chose to go on offense, pivoting to what he called the largest tax leak in history, a reference to the leak of confidential IRS data about wealthy taxpayers that was reported by ProPublica in 2021. That leak was a genuine scandal, but using it in this moment was an attempt to change the subject, and Luján recognized it immediately, holding up what he described as a filing of insider trading transactions right there at the table. That moment, two men slapping a Senate table and talking over each other while lawyers behind them make faces they cannot hide, is an accurate picture of where American institutional trust currently stands. The Senate Finance Committee is supposed to be one of the places where the country's financial laws get scrutinized and held to account. What this exchange revealed is that the mechanisms for that scrutiny are straining under the weight of what is being asked of them. The addendum Luján submitted into the record is now a public document. Chairman Crapo accepted it without objection, which means it is formally part of the Senate Finance Committee's record. That matters. Documents entered into the committee record do not disappear. They become part of the legislative archive. Investigators, journalists, and future oversight efforts can access them. Luján understood exactly what he was doing when he asked for that submission. He was ensuring that whatever happens next, the document exists in an official and permanent place. What you have to ask yourself, and this is not a partisan question, it is a structural one, is this: if the Secretary of Treasury genuinely did not know about a provision in a settlement that his department is party to, what does that tell us about who actually makes these decisions and who they answer to? And if he did know, what does it mean that he chose to say he did not? One of those two things is true. There is no third option. And both of them, in their own way, point to a gap in accountability that this hearing made visible but did not close. That gap is still open. And the people who put that addendum into the record are betting it will not stay quiet. How this settlement impacts the future of financial enforcement, the regulators who manage it, and the congressional panels built to guarantee transparency is an issue that will remain relevant long after this room clears out. But the real question rests with you. Should a high-ranking public official answer for every single agreement signed in their department's name, or are domestic exemptions simply the standard procedure in Washington? Share your perspective in the comments below. To assist our work here at the Politics Report in breaking down these official records and delivering unvarnished institutional scrutiny, please take a moment to like this video and subscribe to our channel. Thank you for watching.